This is WAAY 31 Law Call.
Good evening and welcome to WAAY 31 Law Call. I'm Sharon Dovia. Tonight we're taking your calls and questions all about being hurt on the job. So if you were hurt on the job, would your employer have to keep paying you? Are there some rules? We're talking about workers' compensation, but we're also talking about other forms, other options out there. But if you don't follow the rules exactly, you might goof up and not get what you're entitled to. And then, well, there's all kinds of questions to talk about. If you don't follow the protocols, what if it's going to be a few days you can't work, or a few weeks, or a few months? Call in your questions, the 31 Law Call number 256-536-0077. We will also have some of your email questions. You can email a question on any legal topic any day of the week. You send it to lawcall@waaytv.com. And when we get to a show that's on point, we'll pull some out. We've got some of your email questions tonight. Getting us started tonight, we've got Michael Timberlake and William Meservey, both from Timberlake and League, and they do personal injury cases all the time. We've got William joining us by Zoom tonight, so he'll be, there he is. Hey, William. Thank you for being up with us tonight. And I know you guys do these kind of cases all the time. Okay. We've also got some video to start off with. We like to pull out the You Make the Law Call video. We pulled something off of YouTube that's law related. Check this out. Okay, an accident. We've seen people trying to speed through lights before. Trains are not something you want to challenge.
That's bad. That's a bad situation.
That's a bad situation. There are lots of times when you come across train tracks, it's hard to tell if somebody is stuck on the tracks or somebody's trying to beat the train coming through. Michael, when you see something like this, you've got to be thinking about what are the injuries. But what else are you looking for as a personal injury attorney? What kind of questions do you have?
Well, I mean, so the kind of start with the premise that in a situation like this, the train, the railroad, they have the right of way. And there's obviously stoplights that are set there on the track to try to prevent traffic from coming onto the track when a train's coming down the line. And a lot of people don't understand that. The train actually has the right of way. So you have to yield as a motorist to the train. In this situation, it's very unfortunate. It looks like somebody was trying to pass through and either had some kind of mechanical failure or just didn't realize that the back end of that truck was hanging out there. But and, in this situation, the train, hopefully the engineer and the people on the train were okay, and some heavy damage to some cars, but yeah. The train does have the right of way.
Okay. So workers' compensation, that's what we're inviting folks to call in about tonight, being hurt on the job. William, talk to us a little bit about workers' compensation. What's the difference? If I get hurt on the job, can't I just go to the hospital or whatever, use my regular medical insurance? They're going to pay that, right? They're going to cover my medical cost. Why do I care about workers' compensation?
They're going to cover your medical cost. If you're injured on the job, they're going to cover your medical costs, and that's assuming some basic facts like your employer has more than 5 employees and that you weren't injured as a result of your own violation of a safety rule or misconduct or horseplay. But, essentially the main difference you're going to see is any other way that you're injured where you follow common law principles, you're going to be entitled to pain and suffering and mental anguish. And workers' compensation, it's helpful to think of it more like a compromise. It's a statutory scheme, so it's codified law in Montgomery. It doesn't follow common law, like getting injured in other ways. But, they're going to pay for your medical treatment, and they have to comply with certain other things. The compromise, though, is that you don't have to prove your employer was at fault. And so if you're injured on the job, whether it be your fault or your employer's fault, again, if you weren't horseplaying or violating a safety rule, you're going to be entitled to workers' compensation and the benefits that it provides.
So not proving fault, why is that a big deal? You don't have to prove your employer's at fault. Why is that a big deal?
Well, I mean, it's basically strict liability, like William said, except for, unless there's some kind of defense, horseplay, or safety rule type thing, an employer is going to be responsible for the full extent of workers' compensation benefits, so long as the injured worker was on the job doing their job at the time of the injury. And the reason that it's a big deal is because there are things that can happen on a work site that are not anybody's fault. They're just inherent by the way the work is. If somebody falls, walking up some stairs, if somebody falls or slips in a factory, or some, just an purely incident that's not really anybody's fault, those things are still going to be covered by workers' compensation, and the employer is still going to get the benefits through workers' compensation.
Okay, we've got an email question. Let me give you what Brett had written in. Brett said, I didn't report my injury for a few days after it happened because I hoped it would heal. When I did report it, my supervisor acted like he didn't believe me. He said I wouldn't be able to get workers' comp because it'd been too long and I couldn't prove that it happened while on the job site. That shook me up enough that I didn't file a claim. It's been 2 weeks. I'm still hurting. What do I do now?
Yeah, I mean, this is kind of a difficult situation because, you know, what the law is set up so that people can't come in, you know, weeks after or the Monday morning after a weekend and try to report an accident that happened before then. You know, William, it's pretty strict in terms of the timing that you have to have if it is an accident that your employer doesn't know about.
Yeah, you've got 5 business days. You know, the statute says that you're to provide written notice of your injury within 5 days. Now, a lot of times, your employer receives constructive notice. If an ambulance shows up at your workplace to carry you off, that's constructive notice. Your employer, you know, as long as supervisor or somebody saw the ambulance, you know, you're going to have satisfied that requirement. But by and large, you have 5 days to report an injury. And that's helpful to think of that as an acute injury, right? A broken arm, a fell, things like that, you're going to be held to that 5-day standard. There is some flexibility with other types of claims. Carpal tunnel, for example, or hernia. Those are, well, the carpal tunnel certainly is a more slow over time type of injury. Hernia, actually, you do have a requirement that you have to notice a sharp pain and report the sharp pain to your employer, believe it or not. So, you know, the different types of injuries require a little bit different notice, but by and large, you're going to be held to that 5-day standard.
Okay.
Yeah, and so, you know, the best advice we give people in this situation is, look, if you think you've suffered an injury of any sort, at least report it to your supervisor. You don't have to necessarily get medical treatment immediately. You don't have to go home. But if you've got something that you think is unusual, you know, tell your supervisor, hey, I did this, I've got a little bit of a problem, I don't think it's going to be a big deal, but it's something that I want you to be on notice of. So, you know, even if it's something minor, report that injury.
We've got callers waiting. We've got Josh Lynn on the line with a question from Huntsville. Hi, Josh Lynn. Thanks for calling. What's your question tonight?
Yes, I ended up getting bit by a dog.
Oh, no.
And I went through workers' comp, and they ended up putting me on light duty. And like 2 days later, I sent my job the excuse saying that I was on light duty, and they never responded. And 2 days, they told workers' comp that they had light duty for me, but never responded to me. And 2 days later, they fired me. Well, they said I did a no-call, no-show, but I didn't do a no-call, no-show. They just never responded to me.
Okay.
Yeah, I mean,
can they fire
that's
you
a difficult
for
situation.
workers' comp?
Well, you know, workers' compensation, typically in Alabama, you can be fired or hired for good reason, bad reason, or no reason. You don't have to have cause. They don't have to give you a reason if they terminate your employment. Workers' compensation has some protections built into the process for this very type of situation.
It does. And so workers' comp, one of the things that Alabama's laws do right is they protect those vulnerable employees who have filed a workers' compensation claim. And the law states that you cannot be terminated for having filed or maintained a workers' compensation claim. Now, what you're not going to typically find is an employer who writes you a termination letter that says you're being terminated because you filed a workers' compensation claim. You know, they're going to find some other reason, generally speaking, to terminate you because they have a lot of flexibility in that regard. But you know, to terminate an employee who is not yet even at maximum medical improvement causes great problems for the employer in that scenario. And the caller needs to follow up and have an attorney represent her in that, because, you know, that's something that needs to be investigated further. You should, generally speaking, never be terminated when you're out on leave for workers' compensation. In this incident, it sounds like it's maybe a miscommunication with regards to it, but, sort of a bold step by the employer there.
Yeah. So at any point, if a doctor, you go seek medical treatment from an injury and a doctor places you on restricted duty or light duty, then your employer's got an obligation to either pay you 2/3 of your wage, which is the comp rate for the time that you're out of work, or if they can accommodate that light duty restriction, then they can put you back to work with honoring those restrictions. But they, like William said, they can't just fire you. So it sounds like they had some kind of miscommunication in that terms, and so I would definitely follow up.
Okay.
Now, Sharon, once you reach maximum medical improvement and the doctor releases you from treatment and says, you're all better, you're as good as I can get you. If he releases you with permanent restrictions and the employer can't accommodate those restrictions, then they can legally terminate the employee at that time. But we're talking about before this employee's ever finished treating with the doctor. That employer is walking a fine line.
Okay. They're telling us to take a break. We've got callers that are waiting, so if you're on the line, please hold on. We'll get right back. We're answering your questions about being hurt on the job. Stay with us.
You're watching WAAY 31 Law Call, where lawyers come to help. Your rights, your calls, live. Hosted by family law attorney Sharon Doviet. With the personal injury attorneys of one of the Valley's most respected law firms, Timberlake and League. Featuring the knowledge of managing partner Michael Timberlake, with millions of dollars awarded to his clients. And the experience of attorney Will League, a strong courtroom fighter known for his commitment to winning. And the fellow partners of Timberlake and League Heath Brooks and William Meservey. This is WAAY 31 Law Call.
Welcome back. I'm Sharon Doviet. Tonight we're taking your calls and questions all about being hurt on the job. We've got with us Michael Timberlake and William Meservey from Timberlake and League, and they do personal injury cases and workers' comp cases all the time. Guys, we've got callers waiting. We've got Brandon on the line with a question from Huntsville. Hi, Brandon. Thanks for waiting. What's your question tonight?
Hello. I was just wondering what the perspective from an employer's point of view about how panic attacks and anxiety attacks are handled.
Oh,
and could the conditions of a job that lead to one of those types, could an employer be responsible for the deterioration of an employee's mental health?
That's interesting.
Yeah,
Don't tell us who you work for, but what kind of work do you do?
Service. Yeah, that's the best word I can use.
Okay, that's okay.
Yeah. I mean, so the benefit of workers' compensation is this: is that simply because you have a pre-existing condition or something that you have going into your job, it doesn't mean that you can't get compensation for an aggravation of that pre-existing condition. If you are able to do your job as a normal person without any kind of restrictions before an incident that caused an injury, then you're going to be able to get workers' compensation even if you had the same or similar injury before. If you were physically nearly the same but had an incident and then were not able to do your job, you're going to be entitled to workers' compensation benefits. However, William, it's really tricky with psychological injuries and workers' compensation, right?
It is very tricky, and it is going to matter somewhat the nature of your employment, what your vocation is, and it's going to matter as well, was there an incident that set that in motion, right? So, I've successfully recovered benefits for an individual who was in close proximity to an explosion at a plant, right? And he didn't suffer a physical injury per se, but he required some PTSD-like treatment following that explosion. And so there are circumstances where you could do it, but it does boil down somewhat to those circumstances. So it's sort of a case-by-case basis. But traditionally, they were in a similar category to what we call idiopathic injuries, or things like stroke and heart attack. And for many years, the law didn't recognize ever a situation where a stroke or a heart attack would be covered by workers' compensation. And then one of the hallmark cases that overturned that was where you had an employee working in a warehouse indoors, but with no central air. It was in temperatures in excess at times of 100 degrees inside the warehouse,
Oh.
and he suffered a stroke. The doctors related it due to the work conditions of that employee, and therefore workers' compensation was required to make payment. So similar circumstance here, you would have to have a psychiatrist saying that yes, the circumstances you were exposed to at work have caused your mental health decline or whatever the condition is. But absent a doctor relating it up, workers' comp's not going to just go out and cover an injury like that.
Yeah, I mean, it's like if it's if there's an incident where that related or triggered something, and there's a physical injury associated with it, I don't think there's any question that mental health damages or mental health services would be necessarily provided by comp. There's been a case where there was a 911 dispatcher that dispatched someone to a job and unfortunately heard some very bad things happen to a police officer at that situation. The Alabama Supreme Court in that situation said, no, without some type of physical injury or an incident that you were exposed to at work, you can't make a claim for purely psychological damages. So it's really going to be fact specific.
Very interesting. Okay, we've got Susie on the line with a question from Huntsville. Hi, Susie. Thanks for calling. What's your question tonight?
Hey, Sharon. My question is, I got an injury where I lost a bone and a tendon, and it's been almost 3 years now. Now, since I cannot use since I can't use the left hand, I'm using the right one, and I got a tear. According to the orthopedic, I have a tear in that disc, and it stays swollen 24/7.
Okay.
So what can I do about that?
Okay.
Right. Well, I mean, if it's an injury that you suffered as a result of another injury, it can be compensable. You just have to have the treating physician to say, as a result of this initial injury, she had overuse of the other extremity or overuse of the other leg, and that's what caused this injury. But it gets pretty dicey. It can get pretty fact specific in that too.
Okay, let's talk about these are folks that are not working and they don't have the money to hire a lawyer. How do you hire somebody to represent you in a case like this to maybe sue an employer or whatever you need to do?
Yeah, and we do everything on these cases on a contingency fee basis.
Okay, so they don't have to pay anything up front. Do they ever have to pay? How does that work, William?
No, we cover all the expenses. If we're successful, we get the expenses back. If we're not, we eat them. So the client is actually risk averse in hiring an attorney because the attorney isn't going to charge them until the time that they collect on their behalf. In addition to that, they're going to front the expenses and they will get those back if successful. They won't if they're not. So, by and large, the client doesn't have to bear any risk.
Okay.
Right. The fees in workers' compensation in Alabama are capped at 15% of the recovery. It's a lot different in a lot different states. Sometimes it's hard to find a workers' comp lawyer that will take a case that's got minimal value simply because of the fee limit in Alabama in terms of what they can be compensated for their time. But you should always talk to somebody and make sure you can understand what the situation is before you just give up on a claim.
Okay, sometimes these kind of cases combine with something else, right? So one of the previous callers was bitten by a dog. I'm assuming that doesn't seem like it would be a regular part of her job. Who knows?
Right.
But if you're out doing your job and something else happens to you, maybe you're driving a vehicle for your employer and you get into a car accident, can it combine with a different kind of case?
Yeah, I mean, absolutely.
Go ahead,
yeah,
William.
I insist.
Okay, so There's a sole and exclusivity clause in workers' compensation. And what that means that your sole and exclusive remedy is workers' compensation. But there's some exceptions to that. If a co-employee removes a safety guard, and the one we most commonly see are what we call third-party cases, meaning a third party's negligence was responsible for your injury, and you just happened to be on the job when it happened. So say you deliver car parts for a living, and you're going through an intersection and someone runs a red light and T-bones you. Well, you were on the job, so you're going to be entitled to workers' compensation, but you're also going to be entitled to a negligence claim against the other driver. And since that claim does follow common law, that particular injured worker will be able to recover pain and suffering and mental anguish, but it'll be out of the third party case, not the workers' comp case. So you can have two cases at the same time.
Yeah, and it's a big, if you're injured as a result of somebody else's negligence, you always want to look into that, situation, even if you're getting workers' compensation, because the difference in damages is substantial. The other thing you need to realize is that if you do recover from a third party and workers' compensation has paid for your medical expenses, your time off work, and injury a permanency for what you have, they are going to be entitled to be reimbursed out of a settlement with a third party. So sometimes you look at that situation and say, okay, I've got a lot of medical treatment and workers' compensation has paid a lot of bills. Well, if you're looking for a third party to pay those, you realize that comp is going to get that money back out of the settlement. So it's something you kind of have to work through and negotiate as you go.
Were you guys talking a little bit about safety protocols? Is there something different, like if safety features had been taken off of machines at the job, does that change what you're able to go after?
Well, one is, William, we talked about, is if the employee there's a written safety rule and the employee has violated that rule, then they can't make a recovery. But if there's a device where a safety guard has been taken off, then it takes it out of workers' compensation. The injured employee can sue the manager or whoever took the guard off the machine.
Okay, they're telling us to take a break. We're going to take a break and be right back answering more of your questions about being hurt on the job. Stay with us. If you didn't get your questions answered tonight, here's how to get in touch with Michael Timberlake and William Meservey. They are with Timberlake and League in Huntsville, 256-536-0770 or 800-804-2502. The website is law-injury.com. And if you like them on Facebook, you can learn more about the law that way.
And Sharon practices family law right here in the Tennessee Valley. She does a great job, 256-539-7337. It's divorce, custody, child support, those types of things. And you can find out more at SharonFamilyLaw.com.
Thank you. Okay, remind us how much time, if you're hurt on the job, how much time to tell your boss?
Immediately.
Go ahead and do it.
Go ahead and do it. But if you do it, how many days you got?
5.
5 days. And put it in writing? Put it in writing.
The more information, the better.
Okay. Thanks for all your calls and questions tonight. We'll see you next week.